Hi everyone, welcome back. In my last session, I did discuss on the need to relate the practical aspects with the theoretical aspects of contracting. We did talk about the need to actually not just rely on the bookish knowledge and not just to look at only the law part of it related to contracts, but also to understand the need to look at some of the practical draft contracts and try to relate the law with the draft contract and the clauses within that contract. Now, in this session, I would go a little further ahead and talk to you about negotiations and the strategies related to negotiations and how vital it is that one relates the negotiations to the review of the contract. So number one in negotiations is forming a team and having a good team. And by that I mean that the legal team, the business, the delivery, and the finance should work together and be in sync and on the same page related to all the points and clauses in the contract. And that can only happen if there's a proper teamwork. And by that one needs to actively interact with the respective teams other than the legal team. Obviously, one needs to speak to the account head or the account lead for that particular engagement. One also needs to work closely with the finance. One needs to coordinate well with the delivery and the risk, as well as also take inputs from the HR. So it's vital that one works in close sync and close coordination with all the other teams and take the necessary inputs. And it means that at the inception stage, at the very initial stage of contracting, once the contract is sent for review, one needs to have a very detailed meeting which highlights the key aspects of the deal or understand what are the vital requirements for the deal. So it could be a point related to a third party contractor, or it could be a point related to transfer of personnel, or it could be related to open source licensing, or it could be related to intellectual property. But one needs to have the thorough background and understanding before getting to the review of the draft contract. And that is only one part of it. The next part of it is also making them understand about the legal aspects of the contract. Now, when you are interacting with the business person, obviously the expectation would be that you wouldn't know much about the business side of it. You wouldn't know the technology aspects of the deal. And therefore, it's critical that you ask as many questions as possible to understand all the necessary elements of the deal. Say, for instance, if it is an application development contract or it is an infra contract, you need to know. I mean, what exactly is the software that is getting developed, and what how is the solution getting formed, and and what is the whole process behind it. And you need to ask the basic questions, and one need not feel shy, or one need not hesitate on the fact that that one is not very conversant on a lot of technical jargons. And here I think one vital aspect of it is that one needs to keep learning on the business language. As a lawyer, one is expected to know the legal jargons or the legal language, but one may not be conversant with a lot of business terms. And therefore, I think it's so important that one needs to ask the right questions, and one needs to really find out more about definitions, which are purely business or technical definitions or technology related definitions at the very initial stage of the contracting. So similarly, I think one needs to ask these questions to the delivery spock or the delivery person who is involved in the deal. And even from a charges perspective or from a commercial perspective, there may be a lot of definitions. So, for instance, the definition of resource unit, or for instance, a definition related to benchmarking, which could be a definition of, say, the mean value, or the definition of the benchmarker or competitor. One needs to very one needs to be very, very thorough, and one needs to really work closely with the finance lead. So, as I said, it's a combination, it's a teamwork, and one needs to leave one's ego behind, and one needs to become a student and ask as many questions as possible to understand the business background of that deal. And once one gets a hang of it, and once the lawyer actually he knows the facts and circumstances behind the deal, it's just like a litigating lawyer who needs to be in complete command over his subject matter, or really the facts and issues of the deal, or the facts and issues of the case in hand. Similarly, a contract lawyer also needs to be on top of the business matter or the business case and the facts and circumstances of the case. So, unless and until the contract lawyer is completely on top of the facts, he wouldn't be able to look at the legal risks and advise the team properly on what are the legal issues related to the contract, and following up, then negotiate with the client. So once the teamwork part is done, next is strategizing and really having those calls and meetings internally, discussing those points and placing your points before the teams, making them understand the risks. And obviously, there would be a lot of resistance from the business side and the other teams who would be working closely with the business, the sales. And they would really be trying to impress on you that, well, the business is important, it's vital to realize the benefits of the deal, and it's so critical a deal, there's a lot of revenue at stake, you can't just be telling us about the risks, there needs to be a balance. Well, yes, and how do you strike the balance? The balance is only struck when once you completely understand and the nature of the deal, the background of the deal, and then obviously make them understand about the legal aspects of the contract, and the various clauses in the contract, especially the ones related to liabilities and indemnities, and the ones related to intellectual property, where the business, although they may be knowing the background, they wouldn't be able to appreciate the kind of liabilities that may be purely legal from an understanding perspective. So once you are strategizing about the deal, it's very, very critical that that everybody appreciates each other's points, and then we have a common meeting ground on what to present before the client in the negotiation meeting. That's the second aspect to it. The third aspect to it is when you're going for the meeting, I think there needs to be a clear cut understanding as who has what role in that meeting. So the role play should be done beforehand, before getting to the meeting. So it shouldn't be a case where you are present before the client and the team of lawyers, and surprisingly, one is speaking over the other. So, for instance, if it is a point which purely the HR person needs to speak, and the lawyer speaks up out of turn, which shouldn't be the case. Or if it is a finance lead point, and the commercial lead is expected to present the matter, it shouldn't be a case where the legal lead jumps in and tries to present his point of view. So there should be a clear-cut demarcation of who is presenting what role, and the role play should be well done before arriving at the meeting with the client. Now, it's also so important that one needs to know who is representing the client side. One needs to have a bit of homework done on who are the opposite lawyers, and who are representing the client from the business side, or from the operational side, or from the delivery side, or from the finance side. So there should be clear knowledge and clear understanding about the role plays from the opposite side as well. And then once you get into the meeting, it's so important that you, being thorough in your role, need not be overexcited, or need not really jump the gun, and need to speak only what is necessary and what is essential. And also, if you are in doubt, then not commit anything, rather take a break. Or there's always a provision for or a break during the meeting, so utilize that and don't really think that maybe it's the time to mention everything or just to commit everything, and not think of taking the required breaks during the meeting. The breaks are helpful because there you can regather your thoughts and again recalibrate on a lot of points which you may have missed out, um, and also take suggestions from the other side and be open to suggestions. And also you can even sync up over the phone and try to figure out some of the issues which may not have been properly presented. So so that could also help you in the long run. I mean, you could recover a lot of ground which you may have lost by false presenting or false positioning before the client without acknowledging some of the critical aspects of the discussions. So that's another vital aspect. Then I think it's very very important that you take a very balanced approach during negotiations and not take a very hard approach, or for that matter take a very soft approach. You need to be very clear in your thoughts, but also appreciate from where the customer is coming from, and try to take a perspective which balances both the sides, and not just look at it from your perspective, but also look at from which perspective the customer is coming from, which would help you to close certain points. Otherwise, it's quite probable that a lot of points would keep lingering, and then it may never reach the conclusion as desired. And the whole objective in the negotiation is also to close out some of the issues and not keep many of the points pending for future resolution. Um, so the client expectation would also be that the contract is closed out in the fastest possible time, but then one needs to weigh in on both the aspects, like what are the risks and what are the benefits are coming out from the discussions. And you need to play it smart as well. I mean, you cannot just um think of the benefits, but you also need to look at how you are weighing in on the risk side. And if there are points which would have to go for approvals necessarily, you cannot just end up committing to those points without seeking the required approvals. So it's important to know which points you feel are the most important, which points are medium important, which points are somewhat low importance, and accordingly take decisions on which points you may want to fall back later on, which may points you may want to go back internally and check with your teams or from your superiors, and maybe take the required approvals and then come back and take a final call on those points. And never think that one negotiation is good enough to close out a contract. It will take multiple rounds. So strategizing, uh, these aspects of it is very very important during a key negotiation. Uh, the other aspect that the opposite side would be looking at would be how flexible are you in your thoughts. Being a lawyer is so vital. You cannot be rigid during negotiations. You have to show a certain level of flexibility. And there again, I think the key aspect would be, again, as I mentioned earlier, I think you need to strike the required balance. And how do you strike it? Again, if you have teamed up well, if you have prepared well, if you have done your homework well, I think it eases up a lot of situations. And in case if you're in doubt, then obviously, as I said earlier, you need to take that break, which I think would help you in recalibrating lot of points and taking the right decision. Uh, it's also so important that you don't get nervous. There are tendencies from the opposite side to really feel the pulse and really take certain things straight on and really make you nervous or pressurize you to accept a lot of the points which the opposite sides feel strongly about. But keep your nerves, hold your nerves, be cool, and never ever lose your composure. And just take it in a very very dignified, balanced way. Uh, so, uh, how vital it is that one needs to present the right body language. It is very vital, and your body language says a lot during those meetings. You need to be confident. You need to be sure of what you know, and you need not be overbearing. You need to be presentable, and you need to be shown as someone who is flexible and accepting certain aspects of the discussions, which would go a long way in closing the deal. You cannot be seen as a person who is extremely rigid. I know it does come with a lot of experience, and these kind of requirements really doesn't come in one day. That's why, and that's precisely the reason why I really want to stress on the fact that uh, that when you're reviewing a draft contract or when you mark up a contract, you look at it in a very legalistic way. Look at it in a way that uh, you are looking at it just like a lawyer, a contract lawyer, or an attorney who is trying to protect the company from every associated risks which are present in the contract. But I think that perspective would not work in a contract closure. So the perspective that would work is when you are looking at the deal or the contract in a holistic way, taking every other aspect into consideration, like the business side of it, the commercial side of it. And I'm sure when you look at the contract at the initial stage without really getting to know the complete picture of the business, and why I say this is because the picture keeps evolving, the deal size keeps changing, the commercials undergo a change. It's never the same, and it's ever evolving scenario. So there could be a certain thought process which is there in the beginning of the contract review, and this thought process would certainly undergo a massive change as one starts evolving in the contract. And how does one evolve during the contract process is by constantly keeping in touch with the changing business scenario in the contract. So, for instance, the requirements related to, say, volumes in that particular contract at the initial stage may have been vastly different what it would be at stay at a later stage in the contract, at stage 3 or 4 in the contract. And also the requirements and the needs of business keep changing as one moves through the entire contract process from, say, RFP to RFR, RFI to RFP, and then BAFO and the other stages. So one needs to be very very mindful of it. um, Say one does look at a clause related to, say, liability or limitation of liability, or data protection related liabilities in one light at the start of the contract. But when the deal requirements keep changing, and say the benefits are different and the volumes keep changing, then probably one also gets to know a lot of other finer aspects of the contract, and maybe the way you look at one particular clause at one point of time in the contract process would change as you move on to the next or different stages of the contract. So it's so important that one needs to keep your mind open to a lot of changes that keep happening around you during the entire contract process. As a contract lawyer, when we do review a contract, we just go blindly at certain clauses where we assume things that are very very negative against us, and we mark it up very heavily. And when we start talking to some of the sales guys, we get a completely different picture out of it. And then we realize, oh, maybe we could have taken a different view of this. But what I would suggest is, let's have this view at a very early stage rather than at a stage where we get into a negotiation with the client. It doesn't really help because the client thinks that, oh, probably they made too many changes in the contract review, which were not really necessary. And remember, this whole contracting process is mostly a competitive process where you are fighting with a competition, and the contract review markups and the changes that one proposes is up against a similar contract review done by a competitor, and there is marks given to it, there are points allocated to it. So they would look at how you are actually appreciating the business and how protective you are of your business. If you're overprotective and if you're giving wrong signals, I think that doesn't work well in terms of competition, because competition may just appreciate the business side of it much better and score better points over you, and then actually win over that contract in the later process. So it's so key and vital that you don't really drag in a contract process. You don't really reach a stage where you actually bore the client with too many changes which are not material. And I think that materiality aspect is so critical when one reviews the contract, that the focus should be mainly on the changes that would be substantive enough to make the client think, and really which are worthy of really being negotiated on. Some of the changes we have seen at a later stage really doesn't fly. I mean, those changes really doesn't help uh, the cause, and then we have to drop it. But well, we could have dropped it at a much earlier stage. I keep impressing upon some of the junior lawyers that they look at the broader picture rather than just look at the contract from a risk perspective. And it's funny how things work out, because some of the business guys obviously expect the contract to be closed at the quickest possible time. And once they see a heavily marked up document, they really get jittery, and really start thinking whether this contract would eventually get closed by the lawyer. So it's important that you instill confidence in the business and the teams. See, contract lawyer is a enabler of business. He is not there just to protect the interest of the company. And he is also enabler of the business. And if you do your job properly, I think you would see that you have struck a right balance between the markups that you present to the client, and a- and and the points that you really need to close uh, to actually reach a well negotiated and full-fledged contract. So during this whole session, what I was looking at principally was to impress upon the fact that how critical it is to be on top of the business needs and the business requirements, and how vital that becomes in the whole review process of the contract, and especially related to the next stage, which is negotiations and closure of the contract. So, at three stages, what we have seen is one, obviously, the law aspect of it, the contract law, which we have studied in law schools. The second, the 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 need to relate the law with the practical draft contract, and then the consequent review of the contract with redlining and markups of clauses which are risk prone for the company to mitigate the risk in the contract, and then send it to the business, and then further negotiate on the contract, and then finally reach a stage where we're ready to execute or close out the contract and sign the contract to the satisfaction of the to the satisfaction of the business, the risk, and the legal teams. The organization would appreciate your efforts if you have taken a very balanced view of all the sides of the contracting process. You may just have done a brilliant job if you have probably closed a lot of points in your favor, but you may not have done a brilliant job if uh, you have actually irritated the client or you've dissatisfied the client. So that fine balance has been very tricky. It does come with experience, but as I said number of times during this video presentation, that it's very vital that one needs to be on top of the deal specifics and the business side of it. Thank you so much, and hopefully in the next session we'll talk on some other aspect of contract review, and we'll try to impress on you on so many other strategic and key elements in a contract review process. So contracting has never been a very easy aspect for any lawyer, but we need to be mindful that we are also working for the company as in-house lawyers, and we are not just expected to be a quote unquote a lawyer who is defending the interests of the company, but also a lawyer who is a business enabler. Thank you. Bye.